I-601A waivers were created by the Obama administration to give a big benefit to family members who have an illegal foreigner who's in the U.S. and is barred from the U.S. because they've been in the U.S. illegally for more than 180 days. So, or if they've come in on some kind of a visa, like a C-1D crewman visa or some visa like this, and for whatever reason they're unable to adjust status, or perhaps they came in on a K-1 fiance visa, didn't marry the U.S. citizen, and now they can't marry somebody else and adjust status or do anything because they're prohibited by the K rules or the C-1D rules, or they just entered flat out illegally. In that case, if their only offense is that they've been in the U.S. illegally for more than 180 days, and most after the age of 18, and most are here for years and years, then the way the rules work is in order to become legal based on your marriage to a family member or based on your relationship, as a fiance or as a spouse or as a parenting role or something like this. The only way that you can be made legal is if you depart the U.S. and come in with the proper visa, fiance visa, immigrant relative visa for a parent or a child, or spouse visa or something like this. Something has to be done so that you can leave the U.S. and come back with a proper ticket, because you didn't come in with the right ticket or the right visa to begin with, so now you've got to leave and come back. So this has been a field of immigration where, for many, many years, where when you leave the U.S., you trigger what's called a 10-year bar. So the idea is that if you've been in the U.S. unlawfully present for more than 180 days and you depart the U.S., then you're going to trigger a 3-year bar. But if you've been in the U.S. illegally, unlawfully present for more than a year, or for a year or longer, then you're going to trigger a 10-year bar. And so that's obviously devastating for families. And so the idea, traditionally, under the 601 rules, traditionally was that we go ahead and process a case, whatever case it happens to be. The foreign family member then departs and goes back to their home country. We apply for the waiver, the 601 waiver, at the U.S. consulate overseas. And then once and if the waiver gets approved, then the family member is welcome to come back in the U.S. There's a few problems with that. Number one is a lot of times foreigners don't want to leave the U.S. if they're not sure they're coming back. And when you're talking about a traditional 601 waiver, you want to make sure that you've got a very strong case before you pack your bags and go overseas and sit and wait and hope that that waiver is approved. I've done literally hundreds of cases of 601 waivers over the course of my career, and I've been successful in essentially every one of them. There's glitches and bumps along the way, or reasons why there might be problems, but basically I've been very, very successful at doing the 601. So I won't want to send a family member overseas if I don't feel comfortable in bringing them back. But here's the magic about the 601As. So now that's the 601 waiver where you're processing overseas, right? Well, the 601A is a provisional waiver that was allowed by the Obama administration in 2013 that basically says, look, you're the illegal foreigner. You're working here in the U.S. right now. You've got a family to support. You've got some hardships. So there's some things going on in your life, and you can't afford to go overseas or go abroad, sit and wait for that 601 waiver to process, which could take 4 months, 6 months, 8 months, 10 months, could take a year. It takes a long time sometimes for those 601s to process. And so what the Obama administration said is, look, to promote family unity and keep people together, if your only defect is that you've been unlawfully present in the U.S. and you don't have other issues or concerns, and we can talk about those in a minute, but if you don't have other problems going on with your case, then we'll allow you to stay in the U.S. and process on what's called an I-601A provisional waiver, and that's why you're still here. So we go ahead and process your case. We file for the 601A waiver. Once that 601A waiver is approved, 601A waiver is approved, then at that point you've got all your documents that you need to be able to depart the U.S., go to the foreign consulate, interview for the visa, and come right back. So you're not stuck outside the U.S. for more than the time it takes to go through the interview process at the overseas consulate. So we're talking about maybe a few days or a week or a couple weeks or something like that. But as you can see, the 601A waiver gives you the huge benefit of keeping your family together while we're going through that bar waiver process. And also it avoids the risk taking that if you're sent overseas to do the 601 waiver, or you're sent outside the U.S. to do the 601 waiver, that you may not get approved and you might not be coming back. So, you know, you've got the assurance of a 601A waiver that when you go to your consulate interview, you've at least been cleared for the waiver, and also probably have a pretty good leg up for the rest of case processing on the visa application itself, especially when you're working with a licensed attorney. I mean, that's the idea if you want to play it safe. So then the question arises as to who qualifies for a 601A waiver, and that's where I can share with you some of the screening that I do when I talk to potential clients about the possibility of using that mechanism, that bar waiver application process, to help them become legal and get their green cards. Now, the other thing is you have to have, your only defect can be that you were in the U.S. unlawfully present for more than 180 days, and also after the age of 18, and also that you're not able to otherwise find a way to stay in the U.S. without leaving. So someone says, well, I am in the U.S. illegally, and is there any way that I can stay in the U.S. and not have to go through this process where I'm going to have to get a provisional waiver and go overseas, or do the 601 waiver or something like that? Yeah, I mean, there's very few chances, but there are some cases where people are able to stay stateside. One of them would be if you're the spouse of military, you know, U.S. military, armed services. If you're victim of domestic violence, like you have a U.S. citizen spouse that harmed you. You've got a what's called a U visa, victim of crime. You know, there's some other kinds of things where if you've got DACA benefits, you know, there may be a way to do a workaround when you have DACA benefits where we don't actually have to send you abroad to do your consular processing. There might be workarounds for that kind of thing. So there's a few times when people are calling in, and I'm trying to figure out if there's any way that we can avoid the bar waiver altogether, or find some other avenue to get them relief other than going through the 601A provisional waiver. Okay, so let's suppose that's not going to work. In most cases, you've got the 601A provisional waiver that's on the table that you're going to have to deal with. Okay, the question then becomes, how did you enter the U.S.? So a lot of times people say, well, I entered illegally. And then I'll ask them, well, tell me, a little bit more about how you entered. Did you hop a fence? Did you go through a border check? Did you show a fake ID? You know, did you talk to an immigration officer? You're hiding in the trunk of a car? You know, swim the river? Like, what is, come in on a plane? You know, claim political asylum? You know, what is it that you did in order to enter the U.S.? And the manner of entry itself is, you know, could possibly work to your advantage. So sometimes people think that they entered the U.S. illegally, when in fact it turns out that they were admitted and inspected, and they actually entered the U.S. legally. It may have been fraudulent, maybe you had fake documents or something, but oftentimes it turns out that people will have entered legally. Another problem that I run into is someone says, well, I only entered through the desert one time. And I said, well, tell me about it. And they say, well, I approached the border, I got stopped by Border Patrol, they held me in detention for a couple days, they kicked me back into Mexico, and then the next day I came in. And I said, well, that's not really one entry, it's two entries. So what happens at the border is going to be super important, figuring out whether there's a 601A provisional waiver that's a possibility for you. So let's assume that we clear that. You've got a single entry without any problems. You didn't get picked up. You don't have any criminal backgrounds. You just simply came into the U.S. illegally, and you overstayed your welcome, and you're an adult, and so forth. Okay. All right. So now in this situation, what we'll do is we'll go ahead and file your case. And the real question there is what is it that would prevent you and your family? Why isn't it that everybody can't just pack their bags and move together with you overseas, or to Mexico, or abroad, or to Canada, or wherever it is you guys have to go? Why is it that it's so important that you stay inside the U.S.? So the concept of a 601A bar waiver is to say, look, we know that when you leave the U.S., you're going to trigger a bar. So the question is, what does it take to lift that bar? And if the idea is that you're barred from the U.S., but the U.S. citizen is not barred from living in the other country, then why don't you just go live in the other country? Live in Mexico, Brazil, the Caribbean, Italy, whatever. Just go live somewhere else. You don't have to be in the U.S. If you're barred from here, you don't have to live in the U.S. The other person can, the whole family can just go live somewhere else. And then we have to argue that it would be a hardship if you were to do that. And so what does it take to be successful in arguing for hardship? Well, the idea of a hardship is that your case has to be more compelling than everybody else's, okay? If everybody could have just the normal hardships, which means I've got a job, I've got kids, I can't get the kids to come with me because we've got a court order for sole custody for my ex-husband or ex-wife. I don't speak the language, it's too hot, I don't like the food. These kinds of things, it's inconvenient, it's a lot of crime. If there's these kinds of things going on, the U.S. government isn't going to grant a bar waiver because everybody would qualify. So when the U.S. government says you're barred from the U.S. for being unlawfully present in the U.S., they're serious about it. They're not just going to hand out bar waivers to everybody who wants them. So our project and our goal is to try to make your case more compelling than everybody else's. So if there's 100 cases being filed and they're considering 100 cases, we want to be in that top 20. We want to be standing out as the case that's different from everybody else's so that we can draw attention to ourselves. And filing these 601A waivers is sort of like going to court. I was a trial attorney for many years, and so I know that when you present your case, you can't just tell your story and hope somebody believes you. You can do that and maybe you're going to get lucky. But for the most part, these immigration officers are trained to do their job. And so their job is to find problems and exploit those problems. And if you're just coming in telling your story, it's not going to hold water. So what's important is that you have to have the evidence in support. You've got to have a good story, but you've got to have compelling reasons why it would be an extreme hardship for you if you were forced to live with your family outside the U.S., and you have to have evidence in support of that hardship. But the problem is people very often have an aggregate of circumstances that, taken as a whole, can be compelling, but it's just that they've got a little problem with their children, a little problem with their parents, a little problem with their background, a little problem with their spouse or their husband or their children or whatever it is, a little problem with their work and how they got their work, a little history there that it makes them, their constitution is not as strong as the normal person. There's something going on in their background that makes them different from other people, and why some people have medical conditions, bipolar, whatever. There's something in your background that holds you back that says, look, it's not fair, to move me into that environment. We have to look at where you're going. If the hardship is, gee, I can't live in London, all right, maybe, but why not? But if your argument is I can't live in Syria because they're in the middle of a civil war, okay, well that's going to be a much more compelling reason. So where you're moving and the conditions that you're moving into are relevant too, and they again have to be compelling. So our office handles lots of bar waivers. I enjoy talking to people about how to obtain bar waivers and process spouses and children and parents and distant family members or whatever. I've worked with families for years, and if you have an interest in pursuing a 601A provisional bar waiver, you're welcome to give our offices a call. I'd be glad to discuss. Thank you.